Thank you for joining us. We will begin momentarily. Hello, and thank you for joining the Legal Defense Fund for Civil Rights on the 250th, How the U.S. Supreme Court is Defining Race in America and What Comes Next. Today's conversation will be recorded and posted to LDF's YouTube channel. If you have any technical issues, please email us at events@naacpldf.org. We are deeply honored to be joined by today's moderator, Joy Reid. Joy Reid is a New York Times best-selling author and the Emmy-nominated two-time NAACP Image Award-winning journalist who in 2020 became the first Black woman to host a primetime cable news show at the network formerly known as MSNBC. She is currently a partner at the production company Image Lab Media Group and the host of The Joy Reid Show streaming podcast, available on YouTube at thejoyreidshow.com, on Substack at joyannreid.com, and on all podcast platforms. Thank you again for joining us. Please welcome Joy Reid.
Well, good afternoon, everyone, and welcome to Civil Rights on the 250th, How the Supreme Court is Redefining Race in America, and what comes next. And it is exciting to be here. This podcast, as you just heard, hosted by the nation's first and foremost civil rights legal institution, the Legal Defense Fund. So as you just heard, I am Joy Reid, author, political analyst, and the host of The Joy Reid Show. It is my honor to be moderating today's conversation with LDF's senior leadership, President and Director-Counsel Janai Nelson, and Associate Directors-Counsel Todd A. Cox and Samuel Spital, who are leading LDF at what really could be the single most consequential period in the modern era when it comes to civil rights. So for proof, we need not look much further than the spectacle that we saw last night and that we are going to discuss briefly, but also the Supreme Court. And this term that just ended a few short weeks ago, during which the court was asked to consider foundational questions about our country and about our rights and about who gets to be an American and who gets to have a say in how our multiracial democracy functions. This afternoon, we're going to get into the details on those questions and more. We're going to hear directly from those who are the inheritors of an 86-year legacy of using the power of the laws to achieve racial justice in this country and to remain in the front lines of the fight. And I mean the front lines quite literally, given that, as you all know, LDF's very own President and Director-Counsel delivered oral argument in one of the single most important cases in this term, Louisiana versus Callais. And LDF served as co-counsel in Trump versus Barbera, which challenged birthright citizenship, and Trump versus Miot, which concerned temporary protected status for Haitian and Syrian nationals. So literally the cases that define who is an American. So I'm so excited that we're going to get to hear all of your expertise and these assessments in these political decisions. I'm especially looking forward to getting your perspectives on what this term means for the future for rights litigation and for the ongoing struggle to secure a functional multiracial democracy in this country that works for everyone who calls this country home. So many of you submitted amazing questions um, ahead of this call. We're going to do our best to address each of the issues that you were concerned about. And so let's just go ahead and further this discussion. Let's go ahead and get started. I'm going to start with you, Janai. And I've got to start by asking you about the president's presentation last night, the national address in which effectively Donald Trump claimed that the 2020 election was interfered with, that China interfered, and essentially laid the foundation to take control of the elections on a federal level, which we know violates the Constitution. Would love to get your reactions to what we all heard last night.
Sure. It was rather alarming, and I think it's easy for us to just feel numb to all of the ranting and raving, the warmed over claims that we hear again and again about voter fraud, about election interference and election integrity. But I think we need to take it very seriously. The fact that he took time out to create this platform for himself and try to capture national attention to lay a faux foundation for what is clearly planned voter suppression and election sabotage should give us all significant pause. And I think we were all listening in, trying to wait for, the mic drop of what he was going to do. And it was a long wind up, but at the very end, he said very clearly that he wanted Congress to pass the SAVE Act. That's something that he's been pushing for time and again with Congress. Congress has rejected him many times over since the SAVE Act was first introduced in 2024, but he's been unrelenting. He's held our national security hostage to try to get the SAVE Act passed. He's held up important housing reforms that ultimately did get passed, but he was willing to contribute even more to the affordability crisis in this country by stopping that legislation from going forward. And he also, if we were listening really closely, he made two other really significant threats. He, one, said that he would unleash the power of federal agencies on states because of this claim of election fraud and this myth of voter suppression, voter fraud. And then he also said that he might criminalize some of the actors that he name checked last night. So we have to keep our eyes wide open to what this person is saying he will do to try to win elections for the next 100 years, as he's been saying openly. And even if Congress continues to hold the line, which I hope they will on the SAVE Act, which would be the most massive voter suppression bill on a federal level that this country has ever known, and we've got to call senators and make sure they do hold the line, there are states that are enacting SAVE-like acts. And that is something else that we must pay attention to. There are only 2 states who had these onerous prove your citizenship, show your papers laws when it comes to voter registration and casting ballots. But since 2024, 12 more states have passed SAVE Act-like laws. So this is happening also at the state level. So we've got a lot of work to do to push against this. And we have to turn out in overwhelming numbers, both in early voting and day of voting in these midterms in order to counter these forces.
And to stay with you for just a moment, Janai, because last night the president alleged that more than 200,000 people are registered to vote illegally in the country. He provided no evidence for that. And much of the evidence that the White House purported to provide to show foreign interference actually showed that China did not interfere in the election, and that to the extent Russia interfered, they interfered to help him. But these charges of people voting unlawfully, they're especially chilling given some of the history. Just to go through a couple things, just days before that Great American State Fair, which I did cover, which was very lightly attended, but just days before just before this state fair took place, the FBI raided the office of an Ohio voter registration group. A couple of things, and these are a couple of issues that LDF was directly involved in. Your 2024 report found 2.1 million Texas voters were mistakenly scrubbed from the voter rolls and placed on the on the list of suspected inactive voters. 28,000 incorrect ballots were supplied in poll sites in St. Clair County, Alabama on election day. Absentee ballots were not delivered in time for 3,340 people in Cobb County, Georgia. You had voters who endured 3-hour plus long waiting times in Hinds County, Mississippi, the largest county in the state and the state with the most Black voters. 5 Georgia polling sites in Fulton County were evacuated due to bomb threats on election day. These are all direct impacts on the right of people to vote. How alarming is it from LDF's point of view that the president made a specious claim that there are some 200,000 plus illegal voters registered in the country?
It's deeply alarming. That's exactly why we timed the release of our Democracy Defended report, which is something that we put out after every major election. We analyze voter suppression. We analyze the experiences of voters on the ground because we have a huge election protection apparatus called Black Voters on the Rise, where we connect up with other national election protection efforts. And we ensure that we are documenting the factual incursions on the right to vote, not the mythical ones that the president likes to peddle. So instead of focusing on his own delusions, we believe that the president should really be paying attention to the many real crises that we laid out in our report that are facing our country that disproportionately impact Black people and other communities of color, including abuses of his destructive immigration enforcement apparatus. And, there are real concerns about who will be showing up at the polls in the fall. There are real concerns about people being targeted because they may appear to be non-citizens. And we are making sure that we have the right people at polling sites across the country, that we are armed with information so that people can feel comfortable in asserting their right to vote, which is the right that undergirds every right that we have in this country.
Let me bring Todd and Sam in. Todd, I'm going to start with you because one of the fears, I think, from those of us who were just, taking Donald Trump last night at his word, is that he's attempting to kind of form the basis for a case to take back to the Supreme Court to allow the federalization of elections, which is what the SAVE Act would do. It would federalize elections, and that he's trying to build a case that is rooted in an executive order that he produced in February that laid out the case of why the federal government needs to take control of elections. What are the ways in which LDF is preparing to defend the state-based right to vote? Because it feels like that was brought under threat last night. And that one's for Todd.
Sorry. I think you hit the nail on the head. I think what he's preparing to do is build a case for either precipitously upfront federalizing elections or as Janai alluded to, unleashing the federal government on states to get their voter rolls, which they've been trying to do, or to get Congress to pass the SAVE Act, or after the elections to somehow declare the election invalid and take action that way. What LDF is doing is we're challenging the executive orders. We have been successful up and down the courts, and we've seen courts respond, both in the mail-in ballot situation, where the court said that is not an appropriate use of executive power to contrive a system to double check or to restrain the use of mail-in ballots. We've also seen efforts that he tried to do through executive order to impose SAVE Act type provisions to force folks to prove that they were citizens of the United States. The courts have pushed back on that. We're also at the state level, as Janai alluded to, with our provision, our organization called Black Voters on the Rise, working year round to educate voters about their rights, to modify and fix problems that we see ahead of elections, and to litigate and do policy advocacy to push back on efforts at the state level to curtail opportunities for Black people to vote. The other thing I'll say is that we're working affirmatively to encourage states to impose or to pass their own voting rights acts. As the Supreme Court has curtailed the Voting Rights Act's power and undermined it, we're inviting states to take up their own opportunity to protect voters through what we're calling state voting rights acts. So those acts actually restore many parts of the Voting Rights Act that have been stripped away, but also allow states to adopt provisions that are unique to their needs, whether that's alternative voting methods or other things that really open up opportunity for folks to elect their candidate of choice.
Thank you for that. And Sam, let me go to you on this as well, because it's clear this is a Supreme Court majority that is not exactly a friend to voting rights, not exactly too high on the Voting Rights Act. Clearly, they're not a friend of that either. And if you take the cases in total, this term in total, it appears that the Supreme Court is no longer a bulwark of civil rights, sort of in general. So I'll just ask you to tell me, if you could describe this term kind of in one word, what would it be?
You said it the best. This is not a court that is a bulwark for civil rights. And I think what I would say as the top line conclusion is that this is a term that showed we desperately need court reform. As long as the Supreme Court is in power, the basic principles of our constitutional democracy are at risk. So we've been talking about how those principles are being attacked by the executive branch and by President Trump. But those principles are also at risk because of the Supreme Court. You talked about how the court has, in the words of the dissenting justices, destroyed the Voting Rights Act. They started that destruction in 2013 in a case that LDF litigated, Shelby County versus Holder, where they eviscerated the provision that had made it so that states and localities with particularly egregious histories of discriminating against Black voters, that they would have to ensure that new laws were not discriminatory. And then in the Callais decision that Janai argued so brilliantly earlier this term, the court eviscerated, notwithstanding the force of her argument, which was overwhelmingly persuasive to any fair observer, the extremist majority invented entirely new principles where they eviscerated the remaining key provision of the Voting Rights Act. They then doubled down on that decision weeks later in another case arising out of Alabama, where a federal court, a 3-judge federal court with 2 of the judges having been appointed by President Trump, recognized that the state of Alabama had intentionally discriminated against Black voters in the creation of their congressional map. And nonetheless, the Supreme Court, on what's known as the shadow docket, this docket where they decide decisions in an emergency or an allegedly emergency posture with very little time for full analysis, they said they were going to authorize those discriminatory maps to be used. We also saw this in the case that you talked about earlier, where LDF submitted an amicus brief where Haitian and Syrian nationals had the benefits of temporary protected status, which is a statute that is designed to ensure that folks who are in the United States from countries where it is not safe for them to return are not forced to return to unsafe conditions. And in that case, the administration had revoked this TPS status for both Haiti and Syria. And with respect to Haiti, there was overwhelming evidence that that revocation was infected, at least in part, by racial discrimination. President Trump had said egregious things about Haitian people, that they eat dogs and cats, that they probably all have AIDS, that they and others are poisoning the blood of the country. And the Supreme Court, in light of all that evidence, said, well, there's nothing overtly racial about that, which the dissent just said, you only can say that because you actually don't quote any of the statements. And so this is a court that is actively hostile to civil rights. And I think the other thing that's important to emphasize about it is that it's also not a court that is being transparent about what it is doing. So in the Callais case, which I know we're going to talk about, one of the other things that was so important and damaging about the court's decision is that the court did not acknowledge that they were overturning decades of precedent, which had upheld the Voting Rights Act as a critical, the most successful piece of civil rights legislation. They said, well, we're only updating the provisions of the statute, which was completely not true, as the dissent explained. So you have a court that is both incredibly hostile towards civil rights, but also is not being transparent about what it is doing, which undermines the ability for any sort of accountability. So this is a moment where I think it is clear that something needs to change with respect to our court system, and that means a real serious look at different kinds of potential court reform.
Yeah, I think that is kind of a consensus sort of belief at this point watching this court. And I'll come back to you, Janai, because I take these cases sort of as in total. And what it says to me is that this is a court that has no interest in protecting people of color, of protecting people who are the, children of immigrants or who are immigrants themselves. And for whatever reason they're in the country, they're uninterested in protecting their rights. So when the president of the United States comes out and claims without evidence that there are 235,000 illegal voters, it sets up the potential for hyper targeting of non-white voters in this midterm election. And so give us sort of your assessment, because there's a world before Calais, which you absolutely brilliantly argued, and there's a post-Calais world. We're in the post-Calais world, where you can gerrymander based on race, where you can, take action against immigrants based on race and the president's own racism. How do we protect this country when Donald Trump has signaled he's going to target more than 200,000 unknown people to try to stop them from voting?
Yeah, it's an excellent question. And, if I had to characterize this Supreme Court term and this moment that we're in, it is a clear turning point, right? There have been many indications. This didn't just happen overnight. As Sam pointed out, we knew the Voting Rights Act was on the chopping block from even before 2013 in a case that preceded Shelby County versus Holder, the Namudno case. I mean, this has been a long march to take away what we call the birth certificate of our multiracial democracy. This 60-year-old document that made us a democracy that was beginning to fully take shape and become more inclusive over time, that's now been nearly completely stripped away. There are still some remaining provisions that still offer some important protections like language translation, et cetera. But for the most part, the letter and the spirit of the Voting Rights Act have been utterly violated by this court, and disingenuously so, by overturning over a century and a half of precedent. And so what we need to do in this moment to protect ourselves before we have no tools to lawfully do so through an electoral process is ensure that we utilize the right to vote in the most robust way possible. And it begins with registering to vote and then checking your registration at every turn to ensure that you are still on the voting rolls, you have not been booted off, and there are no other demands made of you to ensure that you have the capacity to vote. So you have to check to see if there have been any new laws passed in your state that require you to show particular identification or anything else to cast a ballot. Everyone should be voting early so that there isn't crowding at the polls. And that, as I said, is just the entry point. What really needs to come on the other side of the ballot is accountability. We have to hold our elected officials accountable. We have to engage in these processes. Like, for example, we know that we didn't just have this week this awful speech by Trump last night, but we also are coming off of the confirmation hearing of Todd Blanche, who has been presented by Trump, his former personal lawyer. He's been presented by Trump as the nominee to be the top law enforcement officer in the country, to lead our Department of Justice. Our Department of Justice enforces our laws, our voting rights protections, our many other civil rights protections. And I can tell you just from the Calais case, we had the Department of Justice on our side when we began this litigation. And then the Department of Justice, when we had to re-argue the case, just the distance between March 2025 and October 2025, the Department of Justice completely flipped its position and became oppositional to our interests and to the interests of Black voters in Louisiana. So who leads the Department of Justice matters. And the Department of Justice must remain independent of the executive. And that's not going to happen if you have someone like Todd Blanche. So we can't just cast a vote. We also have to continually call our elected officials and tell them that we demand that they vote no on nominees like Todd Blanche, that they vote no on deleterious legislation like the SAVE Act. We have to continue to engage beyond the ballot box year round. That is the only way that we're going to bring this country back from the brink of, I think what will be an irretrievable descent into authoritarianism for at least another generation if we don't act now.
Yeah, just to stay with you just for a moment to follow up. I mean, there's also the evisceration of the Civil Rights Division. In my lifetime, it's been typical for LDF and the Civil Rights Division to be on the same side. It feels like that's the opposite now, right?
Absolutely. And this happened in the first Trump administration when my predecessor, Charlene Eiffel, said, we need to step in as a legal defense fund to be the private Department of Justice, because Trump at that time began weaponizing the Department of Justice against us and others. And we know that it's even worse now. We are in a predicament where we don't just have a Department of Justice that is taking a laissez-faire attitude towards civil rights enforcement. They're actually enforcing laws against people who are suffering civil rights violations and exacerbating them. They're turning basic principles like diversity, equity, inclusion, and accessibility, which on their own are the principles that have helped to evolve our nation closer to its constitutional ideals, that have helped to change the complexion of leadership in this country in the best of ways. And what this administration is doing is using our taxpayer dollars to fund our federal government and weaponize those awesome powers against the people, twisting the meaning of words and laws to ensure that the people who need those protections most become the most vulnerable.
Yeah. And Todd, to come back to you, because the other thing to go back to the Supreme Court that it feels like they did was to kind of return the notion of race when it comes to voting, to kind of the bubbles in a bar of soap era, where you can say, well, that's not racial. If you can tell me how many bubbles are in a bar of soap, we're not being racially discriminatory. And they've now sort of substituted partisanship for that, right? So can you just walk us through some of the pragmatic ways that changes the way that states can discriminate against voters? Because if partisanship can be a substitute for race per the Supreme Court, it feels like that's pretty meaningful.
I think that's right. And let me start by saying LDF is a nonpartisan 501c3 organization, and we've opposed efforts by both parties to manipulate map drawing in partisan ways at the expense of Black voters and other voters of color. And what the court did in Callais was strip those rules that governed that process away. And what the court got wrong is that it treats, as you said before, race-conscious compliance with the Voting Rights Act the same thing as racial discrimination. And Janai alluded to this a little bit in her discussion of diversity, equity, and inclusion. And looking at the Voting Rights Act and the use of race and redistricting in that way is a deeply reductive view of both the statute and our democracy. The truth is that Section 2 exists because race has never been incidental to political power in this country. For decades, particularly in the South, where the majority of African Americans live, opportunity districts were the principal mechanism that allowed Black voters and other voters of color to elect candidates of choice. And those districts were not racial spoils. They were a remedy for a political system that had long excluded, packed, cracked, and diluted Black communities and other communities of color. Those are the facts. And what the majority did, as I said before, was turn all of that on its head and to pretend that race and partisanship can only always be cleanly separated. And in many places, they can't. In the South in particular, where the majority, as I said before, Black people, Black Americans live, where voting is often racially polarized and where the remnants of Jim Crow still exist, partisan line drawing that often operates through race. And in analyzing the Voting Rights Act challenges, courts should not give legislatures a free pass to pursue political advantage at all costs. Instead, courts should analyze whether partisanship was being used as a tool, as a proxy, to punish Black voters and destroy their ability to elect candidates of choice. And the distinction should turn on evidence. And the court ignored all the evidence in Callais as well as in Allen. And that evidence includes racial polarization, the history of discrimination, whether communities are split apart, whether alternatives that would not discriminate were rejected, and the sequence of events in coming up with that decision. And whether the map selectively burdens voters of color in ways that can't be explained in ways other than race and race discrimination. The bottom line is, for too long, Black disenfranchisement has been ignored out of indifference or out of a tolerance for partisan chicanery. And what Callais has done is constitutionalize using partisanship to discriminate against Black people.
And to follow up really quickly, does that leave Black voters, voters of color, any place left to litigate? Is there still room to litigate? If you live in a district in some, state where they've decided that they're going to use partisan gerrymandering to redraw districts, and now you cannot elect someone that reflects your interest, it's just not possible based on that. Has the Supreme Court, in your view, left any room left for litigation?
Well, what the court has said is that intentional discrimination still exists. So if that process that develops that racially discriminatory plan was done with intent, constitutional intent, 14th Amendment intent, 15th Amendment intent, you still have a basis for litigating a case. That said, in the Allen case, which the court heard again, there was that evidence of intent, and yet the court ignored it and let the discriminatory map be used. But if you look at Callais, what the court has said is that intent still exists. The other thing I'll add is that we are concerned about going after districts, opportunity districts that do still exist. And it's our view is that just because an opportunity district exists does not leave it vulnerable to discrimination. And LDF is going to be there to defend those districts. Many of those districts were drawn in response to intentional efforts to discriminate against Black people. And under those circumstances, under Callais, those districts are still opportunity districts that should be protected. The court did not disturb what happened in Shaw versus Reno, which says you have a high bar to prove race discrimination and redistricting. That still exists. And we're going to deploy every tool we have to protect opportunity districts that allow Black voters an opportunity to elect candidates of choice.
Thank you. Sam, let me go to you on what was supposed to be the turning point decision that made us think, oh, maybe the court's not so bad. This is the Barbara versus Trump decision. And now this one concerned birthright citizenship. Now, from my point of view, this was a slam dunk that became barely a tip-in, a 5-4 decision that should have been an easy, just read the words, 9-zip,
Yeah,
right?
absolutely.
So can you just explain what the decision was and what the implications of it, not just the actual decision itself, but the narrowness of the decision?
Absolutely. And I'm going to start actually by picking up a little bit of the conversation that you, Janai, and Todd were just having about the Voting Rights Act and the court's decisions there, because in both cases, we have examples of something that had been understood as sort of basic principles undergirding our constitutional democracy, our multiracial democracy, being called into question, and in Callais being essentially eviscerated, and then in this birthright citizenship context, sort of hanging on by a thread. So as Janai pointed out, we saw the Department of Justice flip in Callais just in a period of months. And the other thing that I want to emphasize about that flip is that it is the Department of Justice that for the first time presented this argument that you heard Todd explain in detail about, that the court ultimately relied on, that sort of allows partisan discrimination to be acceptable, and that Black voters to be manipulated as long as the state can sort of say it's for partisan reasons. No one had ever suggested that that was acceptable. In fact, the Voting Rights Act and the principle that we need to ensure that in a multiracial democracy, all voters have to participate in the political process have been something that both parties had recognized and understood when the Voting Rights Act was last considered by Congress in 2006. It was supported 98-0 in the Senate and 390-33 in the House of Representatives. So it wasn't until these arguments started making their way to the Supreme Court, and then in the Callais case presented by this Department of Justice, that we have seen this sort of fraying of this understanding of what should be a foundational principle in our multiracial democracy. So in the birthright citizenship context, which is a case that we co-counseled with our partners at the ACLU, the Asian Law Caucus, and Democracy Defenders Fund, the issue, as you explained it, is would the Supreme Court enforce this fundamental principle of birthright citizenship? And birthright citizenship is a very old principle. It was the understanding of citizenship back in England. It was the understanding of citizenship when this country was first founded. But then something happened. The notorious Dred Scott decision, where the Supreme Court held that Black Americans could not be citizens. And that decision was one of the reasons why the Civil War happened. And in the wake of the Civil War, freed Black people and their allies successfully pushed for the Reconstruction Amendments, including the 14th Amendment. And one of the most important principles that was embodied in the 14th Amendment, although one that has not been litigated as much because it was so well understood to be the law, was this concept of birthright citizenship. So as you said, Joy, the words of the 14th Amendment could not be clearer. They say that anyone born in the United States and subject to the jurisdiction of the United States at their birth is necessarily a citizen. So notwithstanding that unequivocal language and the unequivocal history about why the 14th Amendment was enacted in the first place, when President Trump came back into office the second time, he issued this executive order that purported to, by a stroke of a pen, say, well, no, we're not going to have birthright citizenship anymore for children of certain undocumented immigrants and for children of people who were here in the country temporarily. Would essentially be creating a caste system where some people born in this country would still not be citizens. That case ultimately made it up to the Supreme Court. And as you said, what should have been a unanimous decision was only a 5-4 decision on the constitutional issue. So yes, the good news is that you did have 5 justices who recognized that the 14th Amendment means what it says, that the repudiation of Dred Scott means what it says, and that anyone born in the United States is, by their birth, a citizen, with the only exceptions being for those very unusual categories where someone, even though born here, is not subject to the jurisdiction of the United States fully at their birth. And those are people, for example, children of ambassadors who have a very sort of unusual relationship. But everyone else, if you're born here, you're a citizen here. But as you said, that was a 5-4 decision. And so you had 4 justices in different dissents that sort of came up with a whole panoply of theories about how the 14th Amendment shouldn't be interpreted to mean what it says, that, well, maybe the law can change. And the irony of justices who have sort of been so focused on this idea that actually the law is fixed. Well, when it was not to the benefit of the side they were looking to prevail, they had a different view. Or, well, we're going to not read what the 14th Amendment actually says, and we're going to impose these other limitations on citizenship, which are not actually grounded in the text of the 14th Amendment. So to have these kinds of arguments that would completely contrary to the text of the Constitution and completely contrary to this very basic principle of who we are as a multiracial democracy, as a constitutional rule of law-based society, be so sharply thrown into question by the Supreme Court itself, just shows, to Janai's point, what a precarious moment we are in, and how these foundational principles that undergird our society, something that we all claim to cherish, that we are governed by laws, we are not governed by, simply a decision by any one president. Those rules are really in jeopardy. And so it's a very precarious moment for all of us.
Yeah, and I mean, this webinar is called Civil Rights on the 250th, Janai. And, what frightens me about this decision, which I kind of call the Terminator decision, because it seems dead, but it's only kind of dead, right? It's dead until it reforms like the Terminator did in the Liquid Terminator movies and can come back. Because the way that it was decided, Kavanaugh, his dissent literally said, well, because it violated a law, which kind of almost was like a wink, wink, nod, nod, pass a law that says that the president of the United States can point at any group and say, you're not a citizen, you're not a citizen, you're not a citizen. And as long as there's a law there that we can cling to, go ahead and bring that case back to us. It's terrifying, particularly as the daughter of immigrants, that you could give any president, not just this president, but any president, the power to say there are certain kinds of people who, in the Dred Scott sense, cannot be citizens. It sort of it puts Dred Scott back in play, right? Like, what are some of the implications of that narrow dissent, or that narrow decision?
Yeah, no, you're absolutely right. It's quite frightening, and Sam laid out so clearly why it cannot be overstated how dangerous it is that 4 justices of the Supreme Court ruled against the plain reading of the Constitution, and they broke with their typical originalist approach to the Constitution, which tells you that this was an outcome-driven, case for them in their dissents. They wanted not to follow their typical way of reading the Constitution, but instead to impose a new theory. And we've seen this before. Justice Kavanaugh has served as the sort of fulcrum for the court on a number of different issues. And it wasn't just a wink and a nod and a hint. I saw this as an invitation to Congress to try to come back with a law that, in his words, could amend what we know to be the case, the principle of jus solis, which means, on this soil, if you are born on this soil, you are a citizen of the United States. It is clear. But Justice Kavanaugh has called that into question. So some people call this a 6-3 decision. I think it's really a 5-4 decision if you look at what Justice Kavanaugh did. And of course, both Justices Thomas and Alito argued in their dissents that, the framers of our Constitution could not have foreseen and would not have been in favor of birthright citizenship in its modern form. They're replacing their judgment for these founding fathers that they so revere. And of course, we know that our country was going to continue to diversify. We know that we've had immigration from the moment we unfortunately engaged in the genocide of indigenous persons. We've had people coming from across our shores in the world to populate this country and make it stronger and make it more powerful, and to ensure that we have diversity of leadership and an economy that can thrive and national security. All of the benefits of diversity that are under attack are directly tied to this case and the way we define who can become an American. And Justice Kavanaugh did something incredibly dangerous by leaving this issue unresolved and opening the door for legislation, which is why the midterm elections are so critical. And so we don't believe that this battle is entirely over. Just this week, Senator Jim Banks of Indiana introduced something called the Citizenship Act of 2026, which attempts to codify the president's unlawful executive order that was struck down. And now this case makes it even clearer that, it is not lawful, but it leaves this window open. And, it isn't just Justice Kavanaugh. When you look at the dissent, for example, that Justice Thomas wrote, which was a wholly revisionist misconstruction of the 14th Amendment, and you look at what Justice Jackson presented in response, which I have to say is required reading for anyone who really wants to understand the enduring legacy of the Reconstruction Amendments. And those amendments never fully realized their intent to transform this country from its ignominious history of enslavement and ongoing racial oppression and hierarchy into one where equality truly reigns. You need to read that dissent by Justice Jackson, because she completely shuts down Justice Thomas's effort to recast the Reconstruction Amendments entirely. And the reason why this case was so important to the Legal Defense Fund, and I have to shout out our co-counsel at the ACLU, they did an extraordinary job arguing this case and litigating this case. But it was so important for LDF to be involved because of the misconception about the Reconstruction Amendments that birthright citizenship was only limited to formerly enslaved Africans and their children. And as we explained in our brief, and as Justice Jackson explained in her dissent, that the entire point of the second founding was to rebut this caste, this subordination mentality and ethos, and to reset our nation. And she said so eloquently that the Reconstruction Amendments were not a mere spot treatment for the dark stain of slavery, that this was meant to truly transform our society. Newly freed Black people and their allies worked together to push for a constitution that would bring their own anti-subordination vision to fruition, is what she said. And that's what we're talking about. Black people weren't only looking at their self-interest, they were the founders of a country that was meant to be inclusive for all. And that's why we are taking this moment to be a call for a refounding of our own, right? We want something that is expansive, inclusive, where power is shared, dignity is sacred, and thriving is the standard for all. That's what is embodied in the Reconstruction Amendments, and what is now imperiled by the ambivalence of Justice Kavanaugh and the hostility of Justices Roberts and Justice Alito and Thomas in their very, very hostile dissents.
But Tom, I would put don't leave John Roberts out. I mean, incredibly hostile voting rights, in my
Very,
opinion. I'm not a lawyer, but
very.
the other piece I want to go to,
This
Todd.
one, but yes.
Yeah, exactly. I don't even think you have to be a lawyer to even understand or to enjoy and read these incredible dissents. Justice Jackson's dissents are legendary, as are Sonia Sotomayor's. Todd, one of the things, the sort of bases of a lot of these moves, whether it is killing affirmative action, taking action, to try to end DEI on sort of a federal level and supporting those things, et cetera, is this idea of color blindness. It's an idea that I think for the right feels like progress. But can you explain how this color blindness idea that John Roberts has really championed, and that Clarence Thomas has as well, how does that actually impact the way they interpret the laws? And what do they mean by it, in your view?
Such an important question, and what it really is a denial of the role of that race has had in this country's history, and it shows up in a really terrible way in the case called Students for Fair Admissions versus Harvard. In that case, marked a really important moment in the ongoing struggle for racial justice in this country, and it undermined the most modest consideration of race in Harvard and UNC's undergraduate admissions program. The court ignored decades of legal precedent and placed a significant barrier in front of talented and hardworking students who deserve a fair chance to access educational opportunities by saying race could not be considered at all in deciding admissions criteria. And it was a striking example in which opponents have, in large and small ways, chipped away at race-conscious remedies. And this goes far back beyond SFFA. And it was a culmination of an arc of attacks on policies and practices that sought to alleviate centuries of systemic racism. And I'll give you an example. The Voting Rights Act itself was attacked immediately after its enactment, and then after over decades, ending now with Callais, after Shelby, and after Rucho, and after Brnovich. And over the last almost 3 years, we've seen opponents of civil rights mischaracterize the ruling to justify harmful actions that go beyond the scope of the decision. And that is most exemplified by this administration. Its attempts and others' attempts to impose strict limits on the truthful teaching of history, students' ability to engage, attacking diversity, equity, inclusion, and accessibility programs in both the public and private sectors, the targeting of disparate impact, and racial equity initiatives throughout the government, and attempting to rewrite and whitewash history. All examples of this fantasy that race discrimination never existed, doesn't exist, and race should not be a consideration to remedy race-conscious discrimination. And what we've sadly seen over the past year is a push to abandon and disregard the principles of racial equity in general. And we're being told to stand down from efforts to protect civil rights. And that's really what we're talking about, eroding our civil rights protections. And so, we've seen this rise over the decades. And it's an argument that not only has legal principles, I know we're here to talk about the Supreme Court, but really has narrative principles. And so LDF has steadfastly in our convictions, and we're unapologetic about our commitment to Black communities that face dire conditions. But we are also looking at the fact that this notion of attacking race-conscious remedies is falling on institutions that protect the interests of Black individuals. And so we have to defend our own existence. And so this administration's efforts to mischaracterize lawful uses of diversity, equity, and inclusion, and repeatedly mischaracterize Supreme Court and other courts' decision-making really undermines as I said before, our ability to enforce our obligations under civil rights laws. And as I said before, it's also a narrative conversation. So what LDF is doing in partnership with others is we're doubling down on that narrative discussion. We're doubling down on the need to lift up the call for civil and human rights protections. And we're really focusing in on how we can transform our communications and narrative efforts that we consider to be one of the best tools we have, really doubling down on how we can look long-term at making sure we can turn this around the same way others have looked long-term to undermine it.
Yeah, indeed. And it is not lost, I think, on many of us that the Calais case was sort of the codification of the idea that only white Americans face racism and discrimination. And in this case, a
That's right.
white American who was part of the January 6th insurrection,
That's
Mr.
right.
Calais. The ironies are many. One more question before we get to I want to get to reform and sort of you guys' ideas about reform. I'm going to give this one to you, Sam, because a lot of people who are Haitian immigrants and Syrian immigrants are really terrified in this moment because of the Supreme Court allowing the end of the sort of dramatic and abrupt end of TPS. And especially given the racist characterizations of Haitians that were part of that decision. Talk a little bit about that and the implications for that, and if there are still any remedies left for those folks.
Yeah, I mean, this was another just, I think it's fair to say, egregious decision from the Supreme Court, where lower courts had recognized that the rescission of temporary protected status for Haitian nationals, for Syrian nationals, was infected with the number of legal errors, and at least at a preliminary posture had stayed those decisions by the administration so that TPS would be in place while there could be sort of a fair consideration of the claims through the court process. And what the Supreme Court did was it interfered with that process and said that the lower courts could not continue those stays, that TPS status would be revoked essentially for Haitian nationals, for Syrian nationals. And with respect to Haiti, for example, that means that 350,000 Haitian nationals who live in this country are at risk of deportation to Haiti, where it is clearly unsafe for many of them to return. You asked about what the other potential remedies are, and that will be sort of an individual by individual kind of analysis in many cases, what there might be other sort of bases to prevent deportation. But what we have seen from the Supreme Court, very sadly, is that the broad protection of Haitian nationals, of Syrian nationals, and for other countries that are also facing the removal of TPS protections, that protection is gone. There is a case that LDF is where we are counsel to Somali TPS holders, and we too have achieved a stay of revocation of TPS status for Somali nationals. That decision, that case is still pending, so we have not yet had a ruling, and we'll have an opportunity to explain why we had previously achieved a stay of the TPS revocation there as well, and we'll have an opportunity to explain why that should still be in place even after the decisions affecting nationals and Syrian nationals. But it is bleak. We need to be very honest about the fact that these are bleak decisions. And we talked earlier about how the fact that the way that the Supreme Court just completely whitewashed the absolutely unequivocal animus statements by President Trump targeting Haitian nationals. And there are real consequences for that. When the government previously had recognized, and administration after administration recognized, that right now conditions are not safe for Haitian nationals to return to. And then when you have an administration that is using this sort of racist rhetoric and then making decisions that are affecting people's lives, that are jeopardizing people's lives, that is the consequence. And that is the consequence that the Supreme Court approved in the TPS decisions.
And I'll note that we are running short on time, but there's so many other cases of groups that are at risk, Sam, that include cases of LGBTQ individuals. Very quickly, if you could very briefly give us 30 seconds on what else we need to be. Scaring is caring. Tell us what else.
So it was another very difficult term for LGBTQ persons at the Supreme Court, where the court sort of upheld bans on transgender girls playing school sports, even when transgender girls had taken medical treatment, so there would be no sort of athletic advantage by the sexes that they were assigned at birth, where the court have sustained a constitutional challenge against a law prohibiting conversion therapy, which is this very dangerous practice that tries to convert queer people to change their sexual orientation or their gender identity. It was also a really big term for executive power. And, I would just say very briefly, the theme there is kind of similar to what we heard before. There was, on one hand, some decisions, notably the Slaughter decision, where the court really greenlit the president having almost complete control over a lot of executive agencies, including agencies that previously have been understood to be independent. And then even decisions where you had a very narrow majority making a very narrow decision that sort of protected against some of the worst abuses of executive power, like in the case where the president tried to fire Lisa Cook, a Black woman, one of the federal board of governors, based on allegations about essentially misstatements on a mortgage application. Even there, it's a 5-4 decision on very narrow grounds. So you see that even in the decisions where there is some level of limitation, we're really hanging on by a thread.
Yeah, indeed. And we could go into death penalty and all these other things, but we are out of time. I want to throw it back to you, Janai. And if you could, in your closing, address some of the ideas for reform. What can we do? What would actually make this court more effective at sustaining and defending the rights of the American people? I want to thank LDF for doing this, and throw it back to you, Janai. And if you could throw into your closing some notes on potential reform.
Sure. Lots of folks are talking about Supreme Court reform, and it's not a new conversation. I think many of you have heard about the commission that President Biden put together during his term. Even prior to that, people have long questioned whether our Supreme Court justices should have lifetime tenure. We've talked about the lack of adequate ethics on the court. And LDF has taken this conversation very seriously. We have engaged with the court for over 86 years in a very robust intellectual dialogue, if you will, through litigation. And we've won some extraordinary cases like Brown versus Board of Education, ending state-sponsored segregation in public schools, which led to the desegregation of our society by law. And we've also lost some critical cases. And we've never been in a position to have to call for Supreme Court reform as vociferously as we are now. And that is because of everything that you heard today on this call and the summary of cases that Sam was able to at least give a little bit of description of. This Supreme Court term, as I said at the outset, was really a turning point. It was a turning point for us as an institution to embrace Supreme Court reform. And some of the reforms that are most urgent obviously involve ethics, right? We cannot have a Supreme Court filled with individuals who can be captured and compromised because of gifts or affiliations with people who may have ulterior motives, or be trying to use this incredibly powerful third branch of government for reasons that are self-interested. And every other judge in the country is bound by ethics. We must make that so for the Supreme Court, and not just aspirational guidelines, as Roberts put into place a couple of years ago, but something concrete and enforceable. So we must start there, and that should be something that no matter what your political affiliation is, you can support. But we also need to dig a little deeper and look at reforms that involve the shadow docket. I think Sam and Todd both referred to the emergency docket that has been lingering in the shadows, where the court issues decisions of such import and moment. And often we don't know the author. Often we don't know what the reasoning was. Often there was absolutely no record, no briefing, no real engagement of critical issues that wind up having severe consequences for our society and for the people in it. As of March of 2026, the second Trump administration asked the court to intervene when lower courts had blocked some of its worst actions 34 times. That's more than President Biden and Obama and George W. Bush combined. So he is using and weaponizing the court's shadow docket in some very disturbing ways. And the court has issued 25 decisions on the shadow docket and ruled in the administration's favor 80% of the time. So that calls into question separation of powers. When you layer on the lack of ethics, when you add to that the term limits that these justices don't have, and they have lifetime appointments, which means that we are now stuck with the composition of the court until there's some particular change. And we need to have a serious conversation about whether court expansion and term limits should also be on the table. And we need to prime ourselves to reconsider this, because it will be a critical question as we move forward with the next Congress. But I really want to close by thanking you all, and thank you, Joy. We are all so much better for your extremely thoughtful questions and your engagement of issues of racial justice. And I want to thank our Associate Directors-Counsel, Todd, Cox, and Sam Spital for sharing their insights and for their extraordinary partnership. As was made very clear by the actions of the justices this term, by the president's speech last night, this upcoming election will require absolute vigilance. LDF is in the courts. We are in the streets. We just intervened in a case in Mississippi this week. We won a battle against the United States Postal Service at an important stage of the litigation to ensure that mail-in balloting can continue, and we will continue to fight for that as we head towards the elections. We will have boots on the ground across the country in the upcoming election to make sure that people are protected. And all of this takes resources. All of this takes your engagement as well as poll workers, as defenders of democracy. So we invite you to support our work. You can see on the screen that there are ways to connect with us, to donate, to get involved, to stay informed. I hope you will consider making a contribution to our Democracy Emergency Fund via the QR code on your screen. And through your generosity, we can continue the legacy of this great institution founded by Thurgood Marshall. We are fighting for civil rights, and we need everyone to take up the mantle. So thank you for being here, and have a wonderful weekend.